Good morning, this is the Kelso Report for Thursday, August 18th. I'm your host, Clark Kelso. We begin today with one of those grand old doctrines of the common law, the parole evidence rule. According to the rule, as codified in CCP section 1856, terms set forth in a writing intended by the parties as a final expression of their agreement with respect to such terms as are included therein may not be contradicted by evidence of any prior agreement or of a contemporaneous oral agreement. Now, the terms set forth in a writing, such a writing, may be explained or supplemented by evidence of consistent additional terms, unless the writing is intended also as a complete and exclusive statement of the terms of the agreement. That's the parole evidence rule in general. Well, the rule was examined and then put to one side in the First District's opinion yesterday in Thompson versus Canyon, where the plaintiff sued her real estate agent for breach of fiduciary duty when the agent allegedly failed to include in a purchase agreement selling the plaintiff's house an alleged oral agreement the plaintiff had with the buyer to reconvey the house back to the plaintiff after the buyer had cleared all liens on the house, in return for plaintiff's promise to pay the buyer the amount of the price buyer paid to pay down the liens, plus an additional $10,000 fee. In fact, this alleged oral agreement did not appear at all in the purchase agreement, which was drafted as a straight sale of plaintiff's property for only $440,000, significantly less than the property's $545,000 market value. You can probably guess what happened next. The buyer did not reconvey the house back to the plaintiff in order to collect his $10,000 fee. Instead, within just a few months of closing escrow, he sold the house to a third party for $580,000, pocketing a tidy profit of $140,000 on the deal. The plaintiff had originally sued the buyer for fraud, but lost at a bench trial, in large part because the court applied the parole evidence rule to prevent the plaintiff from introducing evidence of the alleged prior oral agreement with the buyer. Plaintiff then turned to her real estate agent and sued for breach of fiduciary duty and professional negligence. The real estate agent tried to use the parole evidence rule to prevent the plaintiff from introducing evidence of the alleged oral agreement between the plaintiff and the buyer, since that alleged oral agreement was not reflected at all in the purchase agreement, which both the plaintiff and the buyer had signed. After all, the parole evidence rule had been used successfully by the buyer to defend against plaintiff's fraud claims, so the real estate agent thought it should work for me too. Well, unfortunately for the real estate agent, the parole evidence rule, that's one of those somewhat disfavored old common law defenses for which there are exceptions aplenty. In this case, the First District held the parole evidence rule did not apply at all because the plaintiff was not offering extrinsic evidence to reconstruct her contractual obligations or the obligations of the buyer under the purchase agreement. Instead, the dispute before the court related to the obligations of someone who was not party to the contract, that is, the real estate agent. And the issue was whether they had breached their fiduciary obligations to the plaintiff by failing to reflect the alleged oral agreement in the written purchase contract. As the court noted, the plaintiff's case was similar to one in which a contracting party alleges that his or her attorney committed malpractice in negotiating and drafting a document. The parole evidence rule does not apply there. It prevents reconstruction of the party's contractual obligations, but it does not immunize real estate agents, attorneys, or other professionals from liability arising from their alleged misconduct in drafting a document. And now our one-liners for today. We first begin a Freedom of Information Act case in Jana Moto versus Department of Veterans Affairs, where the Ninth Circuit considered a Freedom of Information Act request that was made by an employee of the Department of Veterans Affairs for certain emails between other employees of the Department of Veterans Affairs. Ultimately, the department disclosed all of the emails to the plaintiff, but only in his capacity as an employee of the department. By this conditional limited disclosure, the department hoped to moot the plaintiff's FOIA claim while still not making a disclosure that would essentially make the emails accessible by the general public. Well, the Ninth Circuit rejected this argument, holding that by placing the condition on the disclosure, no further disclosure by the employee, the department had actually failed to make a full disclosure as required by FOIA. So the case was not moot. On the merits, the Ninth Circuit held that 9 out of the 157 emails requested contained information that properly should have been redacted pursuant to FOIA's Exemption 6 for, quote, personnel and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy, close quote. Most of the private information related to medical issues that were discussed in the emails. And the remainder of the 157 emails were fully disclosed in order to be fully disclosed by the court. Well, next, an Americans with Disabilities Act case in Oliver v. Ralph's Grocery Company. The Ninth Circuit affirmed summary judgment granted to the defendant, Ralph's Grocery, in a claim brought under the Americans with Disabilities Act, involving a customer who uses a motorized wheelchair to get around. Ralph's had cured a number of the alleged architectural defects by the time the district court granted summary judgment, and the court rejected the other alleged architectural defects because, although the architectural features were inconsistent with the California Manual on Uniform Traffic Control Devices, they were not in violation of federal ADA standards. And the court held that a violation of the California Manual is not a per se violation of the ADA. Next, an insurance case. In Villa Los Alamos Homeowners Association versus State Farm General Insurance, the First District extended to the first-party property insurance policy context the California Supreme Court's interpretation of the standard pollution exclusion clause in a comprehensive general liability policy. In McKinnon v. Truck Insurance Exchange, the Supreme Court had interpreted the general clause to exclude coverage for injuries resulting from events commonly regarded as environmental pollution, and as not excluding activities that a reasonable policyholder would not think was an act of pollution. Now, in McKinnon, the court held that the exclusion did not apply to the normal but negligent spraying of pesticides around an apartment building in order to kill yellow jackets. The First District extended this narrow definition of the pollution exclusion to a first-party insurance context. In applying that definition, the court held that the disturbing of asbestos during the scraping of acoustical popcorn ceilings in a residential building, in which asbestos fibers then were released into the air, the common area hallways and stairwells, individual units, and out to the common areas and public spaces, well, that did constitute environmental pollution, subject to the policy exclusion. So spraying for yellow jackets, that's not pollution. Asbestos is pollution. Next, we have a case involving preclusion. In Bullock versus Philip Morris, a split panel of the Second District held that the settlement a decade ago by the Attorney General of a suit against Philip Morris and other tobacco manufacturers did not preclude an action by an individual for compensatory and punitive damages for personal injury and death, since the AG's action was to remedy an entirely different harm: economic injuries to the state and injuries to market competition, such that a different primary right was involved in the AG's suit than in the action for personal injury damages before the court. Accordingly, because a different primary right was involved, res judicata did not apply. The court then affirmed a $13.8 million punitive damage judgment on top of an $850,000 compensatory award. The dissenting judge in the case would have reversed the punitive award, since the ratio of punitive to compensatory damages was 16 to 1, which the dissenting judge found to be unconstitutionally large. Next, criminal sentencing. In Miranda versus Brats, the Ninth Circuit upheld, against a habeas challenge, multiple consecutive sentences that had been imposed on a defendant who was convicted of 8 criminal violations arising from a single criminal transaction. The defendant, being drunk, chased a minor across a tribal reservation while brandishing a knife. The defendant was convicted by a tribal court of 2 counts each of endangerment, threatening and intimidating, aggravated assault, and disorderly conduct, and was sentenced to 910 days of imprisonment based on a series of consecutive sentences. The district court concluded that the consecutive sentences violated the Indian Civil Rights Act, but the Ninth Circuit disagreed, holding that Section 1302 of Title 25 unambiguously permits tribal courts to impose up to a 1-year term of imprisonment for each discrete criminal violation. Next, we have a qualified immunity decision. In Ammons versus Washington Department of Social and Health Services, the Ninth Circuit held that the chief executive officer of a residential psychiatric hospital was not protected by qualified immunity because the CEO had personal knowledge that one of his staff had previously been investigated for sexual abuse of a female patient. Yet the CEO allowed this employee to continue working at a cottage housing female patients without taking any steps to ensure that he was not given repeated opportunities to be alone with one or more of these patients, and failed to take any action in spite of increasing and documented evidence that the employee in fact was having an inappropriate relationship with one of the patients in the cottage. This failure to act violated clearly established constitutional obligations to exercise professional judgment in the management of the facility, thereby depriving the CEO of the protections of qualified immunity. And last, a labor law case in Barret versus Brayton Purcell. The First District held that a law school graduate who worked at a law firm as a law clerk before becoming licensed to practice law in California was still an employee engaged in a learned profession. Accordingly, the law firm did not have to pay the plaintiff overtime wages and other benefits allegedly required by California law, such as meal and rest breaks. Apparently, the plaintiff missed that day in law school where he was taught that he was entering a learned profession. And it is not the license which makes you a professional. So no overtime for law clerks. That's it for today's Kelso Report. I'm your host, Clark Kelso. Have a great day in the law.